I got a lot of good deposition questions, so let's get into it. I got a lot of questions about who is there. So let's set up the scene. When there's a civil deposition, it's typically in a conference room somewhere that one of the parties has rented out. And it's a big room with a big table, your typical conference room. You'll have your court reporter there, so that's the stenographer that's taking down every word that is said. And many times there's a videographer. So there's someone with a camera that has a backdrop behind the deponent setting up the mics. So those two people are hired from outside that come in. And then the client is there. So the deponent, whoever is being deposed, will obviously be there. Their lawyer. So they could bring one lawyer, they could bring a team of lawyers. Usually you don't need more than one or two lawyers in the room when someone's being deposed. Only one lawyer is allowed to object at a time, meaning only one lawyer can be like, I object to the question that's asked of my client. And on the other side is the lawyer that's taking the deposition, so asking the questions, and they might have another lawyer with them or a paralegal with them. But again, you don't really typically see more than one or two lawyers from each side being present for a deposition. Now, every deposition in a civil lawsuit, the parties are entitled to be there for the deposition. So in the Lively Wayfarer case, if Blake Lively is the one that's being deposed, then the other side, the other party being Justin Baldoni, Wayfarer, Jamie Heath, Steve Sarowitz, all those people are entitled to be there because they are parties to the lawsuit brought against them. So they're allowed to sit in the room and listen to what the testimony is going to be. Now, I don't know if that's going to happen here. It's not typical that all the parties show up to every deposition. Sometimes there's one representative from the each side that is there, and sometimes no one from that side is there. So it really just depends on the comfort level of the parties and whether or not they want to be in the room when the deposition is taking place. So I got a lot of questions about whether or not the judge is going to be in the room, and almost never judges interfere physically into the room where a deposition is happening. So the parties will resolve those issues outside of the deposition generally. What does that mean? That means that if a question is asked and the deponent refuses to answer it, or there's some kind of issue and the objections get heated, it happens. I've been in that setting with a heated deposition objections. Sometimes if it's really time sensitive or critical, or the parties are in an impasse and it can't proceed, they might call the judge together and ask the court to have a sort of ex parte meeting with the parties together to resolve a specific thing for the deposition to continue. Even that is extremely rare. Almost never you want to bother a judge that has a ton of other cases to deal with to resolve your little objection issue in the deposition. So instead, what happens is it's all preserved on the record. So what the court reporter is writing down, it's all preserved on the record and fought about at a later time. So let's say there's a question on the table and the deponent refuses to answer it. And the questioner is like, you have to answer it. You can't get out of this one. This is problematic. The lawyers fight about it on the record. They create a record of their position. They're at an impasse and they're like, we're preserving this to resolve this with the court later. What that means is that the record is all there. So when the transcript is printed and sent to the parties, then the party that's like, I'm upset because I didn't get the answer to the question I wanted, I'm entitled to it under the laws, then they will move to compel the answer to that question from the court, referencing that specific part of the transcript that shows the argument between the two sides and the deponent's refusal to answer. So usually issues that come up in a deposition are preserved on the record on the transcript and resolved afterwards by the court later. Someone asked, how will we know whether the deposition took place or not? Well, we'll probably find out. We'll probably hear whether or not it happened just because of the publicity of this case. But typically speaking, parties can't get out of depositions. You can't avoid your deposition forever. If you are suing someone, you can expect to be deposed. And if you don't show up, there will be a filing in court moving you to compel to show up. So we will learn about the procedural history of whether or not a deposition happened or not, if there's a refusal to participate in the deposition. There is a transcript, like I said, that's created from the deposition that is not released to the public. It is not filed with the court. Later on, excerpts of it will be used as potential evidence, whether it be at a summary judgment stage or whether it be at trial. So the excerpts from the transcript will eventually make it into the public record potentially, but we don't ever get to see the full transcript unless the full transcript for some reason is put into the public record, which I highly doubt. I got a question about spousal privilege. It's actually a very good question and it's highly relevant in this case. It's something that I've been thinking about a lot with respect to the communication between Blake Lively and Ryan Reynolds and what aspect of that is privilege, what aspect of it is not. I think I mentioned in my last video that pretty much any question is fair game at a deposition and you have to answer everything, even if you feel that it's not relevant or that it potentially can't be entered into evidence. With respect to spousal privilege, it's a little nuanced as well. I mean, technically you don't want to be asking a deponent questions specifically about what did you say to your husband. So you'll find other ways to get the information that you're looking for that doesn't directly implicate the spousal privilege. But typically speaking, communications between a couple, just directly between a couple, are protected and they can't be, or they're privileged rather, so you can't really use them as evidence or seek them as evidence. Of course, there are exceptions to that, but generally that's what that is. Here's a question about lying under oath and how do you prove that? Well, when you are sworn in by the court reporter, you are essentially saying that I am testifying truthfully. And it is the same exact oath that you would take, for example, if you were in a trial and you were brought up onto the witness stand and you were asked to testify at a trial. So it carries the same exact weight. That doesn't mean that people don't lie or try to or get around lying. It happens, but lying under oath and being caught lying under oath, like blatantly lying under oath, is a serious offense. And you don't ever want your client to do that because it's severely problematic, could potentially be criminal if they do. One thing that you'll see is that suddenly a witness loses all their memory and they can't remember anything anymore. And so you'll ask them questions about, well, what happened on Monday and what happened on Thursday and why did you send this email? And they'll be like, I don't know, I don't remember. And so that's when lying under oath goes under this gray area where it's like, well, is it really lying? I mean, how can you prove that they don't really know? And you don't really have the time and resources to dig into what their memory capacity is to prove that they did in fact remember, but they're pretending not to remember. And so there's sort of a gray area with this, and it does look really bad if you remember one thing very clearly that happened on, let's say, Thursday of the week before, but then you don't remember at all what happened the very next day, and you don't have a very good explanation for why you don't remember what happened the very next day. So that's when the credibility of the witness comes into play, and that's what the juror's job is to figure out how credible is what they're testifying about credible. So like if they remembered what happened on Thursday but suddenly forgot what happened on Friday, how credible is that to them? So this is sort of where the law gets a little bit mushy and not totally clear, and that's how a lot of people get around from lying under oath. Somebody asked about whether she could take the fifth. The fifth only applies in criminal contexts. So you plead the fifth when you don't want to incriminate yourself, meaning under a law, you don't want to testify as to something that could be held against you in a criminal court of law. So I don't really see how that could play into this case at all. I don't see how there are any criminal laws that are at issue or like illegal in that sense. So I don't see how that would come up or happen here. And you can't refuse to answer if you just don't want to. That's just not an option. My prediction is that the deposition won't complete today. It will be a partial deposition in which questions will be asked leading up to the discovery that has not been turned over yet. And once that discovery is turned over, it will make sense for them to seek leave to continue that deposition.